Good morning everybody and welcome to this meeting of the local review body of the 11th of June 2014. I can confirm that the meeting has been properly called and is quorum. Can I please ask members to appoint a chairman for the meeting?
I'd move Councillor Dempster.
I would second that, mate.
Okay, Councillor Dempster, thank you.
Good morning, ladies and gentlemen. Welcome to the Local Review Body, 11th June 2014. Can we have Sederunt and declaration of interest, please?
All members present this morning, not aware of any declarations of interest.
Thanks, Claire. Can you take us through the process, please?
Thank you, Chairman. I can confirm that there are two notices of review for consideration at today's meeting. The first being item 4, Lakehead A Village, Parkgate, Dumfries, refusal of application to remove condition 4 of planning permission TP 478 and condition 5 of planning permission TP 59678, restricting occupancy of dwelling house 13B30491. The grounds for refusal in this case are on page 64, that being that removal of conditions 4 and 5 of planning permission TP 478 and TP 59678 respectively, which restricts the occupancy of Lakehead farmhouse, would be contrary to Dumfries and Galloway Structure Plan Policy D4, which requires proposals for dwelling houses in the countryside to be essential for the needs of agricultural and other rural uses. The requested method of determination for this case is that the applicant has requested that the review be dealt with on the basis of one or more hearing sessions. The grounds stated in the notice of review are, in summary, that the decision was issued whilst there were ongoing discussions regarding a certificate of lawfulness. The applicant considers that the grounds for refusal are contrary to the advice given by the former Chief Planner in a letter dated 4th of November 2011. The applicant considers that condition 4 of planning permission TP 478 and condition 5 of planning permission TP 59678 are flawed due to not defining what locally means. We also have the comments of other interested parties, the relevant sections of the development plan policies, and the main issues for the LRB to consider are: does the proposal conform with the relevant development plan policies, and in particular structure plan policy D4? Has there been any shift in development plan policy since the original 1978 planning permission was granted, which would justify granting a new permission without condition 5? If the LRB considers that the proposal does not comply with the development plan, are there any material considerations which would indicate that planning permission should be granted to the contrary? What weight, if any, does the LRB wish to give to the letter from the former Chief Planner dated 4th of November 2011 and the applicant's particular interpretation of it? Are there any other remedies available to the applicant which would be more appropriate but which would have the same effect of making the development immune from potential enforcement action to the current and future occupiers? So, having outlined the documents within the members' papers, it now falls to the LRB to determine whether it has sufficient information to consider the review. It is confirmed there will be no representations from any party heard today for this or the case that follows. And the options for this review and the case that follows are that it can decide that it has sufficient information before it to enable it to determine the review today. request further information in the form of written representations, the LRB would have to state precisely what information it was looking for and who would provide it. Resolve to hold a hearing, again specifying who would be invited to speak and on what matters. Resolve to hold a site visit, accompanied or unaccompanied. This can be done in conjunction of the above, but would obviously not allow a decision to be made today. And if the local review body resolves that it has sufficient information and no further procedure is required, then the local review body has the full powers to uphold, reverse or vary a determination. The decision notice will include a statement of the terms on which the planning authority has decided the case reviewed. A planning advisor is present at today's meeting. It's confirmed he did not have any involvement in either cases or is not the case officer or appointed officer for the applications. He is here purely to provide independent advice as needed on matters of planning policy, law or process to the local review body. If members are clear and no further clarification is required, I will ask the chairman now to lead the debate and in the first instance to lead the local review body through the agenda papers together and decide if it has sufficient information before it to make a determination today. Okay.
Thank you, Claire. Councillor Geddes.
I would suggest, sir, we do have sufficient information to deal with it today, and I would not be in support of, deferring it for a hearing or hearings.
Thank you for that, Councillor Carruthers.
Thanks, Chairman. Just, I only have a basic understanding and knowledge on certificate of lawfulness. I wonder if we could get some kind of reassurance that we've got that a fuller understanding here if asked for. That's the only piece of information that I would be required, but I think hopefully our independent planning officer would be able to advise us at the right time, Chairman.
I'll ask Robert to explain the nature of certificate of lawfulness for us.
Well, even if I get a reassurance, I would ask at a later time, Chairman. It just that's because if you're asking me procedurally, do we need to defer for further information? If I get a reassurance that that knowledge is there, then I'd ask at a later time.
Robert.
Thank you, Chair. As a local review body, what you're looking at today is you're reviewing a decision made on a planning application. I understand that a certificate of lawfulness has been submitted in respect of the occupancy of this house, but that is a separate application for a certificate of lawfulness and it isn't subject to the review today. What you're reviewing is the decision taken relative to this planning application. The certificate of lawfulness application has been dealt with as a separate matter, but obviously the outcome has implications for the same applicant.
The question that I asked, Chairman, was do we have the knowledge on if I ask for a piece of information on certificate of lawfulness, is that information available to me? That was the question I asked.
I would suggest then that to simplify matters, we'll ask Robert to explain what a certificate of lawfulness is, and if you're not satisfied that you have enough information, that will then allow you to make a judgment personally. So Robert, could you explain what a certificate of lawfulness is, please?
Sorry, I mean, you've got two basic types. You have a certificate of lawfulness for an existing use or activity, and you have a certificate of lawfulness for a proposed use or activity. What you're looking at in this scenario is a certificate of lawfulness for an existing use, and as I understand it, that's been submitted on the basis that the same applicants for this planning application have made a certificate of lawful use application in respect of their occupation of this dwelling house. And essentially what they're trying to do is demonstrate that over a relevant period of time, in this case 10 years, that they have occupied this dwelling house without compliance with the condition that's under consideration before you today. So in essence, it's a matter of fact and degree in terms of the information submitted. The relevant person looking at that determines that the planning authority take a view as to whether they're satisfied that the information submitted demonstrates beyond reasonable kind of doubt that the use in question is lawful. So in this case it would be 10 years, and if that was the case, you would find the situation that they would find themselves in a situation whereby it wasn't necessarily authorised, the occupation, but the council wouldn't be able to take enforcement action against that. So
thanks, Chairman. I think with the information that's been put forward here by Robert, that he has got the level of information that are required, and I'll ask that question at a later point in time. Thank you.
Thank you for that, Councillor Carruthers. Councillor Geddes.
For absolute clarity, sir, are we saying, in fact, in these particular circumstances, that the certificate of lawful use runs with the land, or is it personal to the current occupier?
I think it's personal, because I think one of the requests contained within the document is for a in perpetuity, and I don't think officers have considered to do that. But Robert, would you just confirm that, please?
Given the nature of the condition, it relates to who's actually occupying the dwelling house at any particular point in time. So, it would depend on the outcome of that certificate of lawfulness application, which hasn't been determined yet, as I understand it. But yes, it would depend on who is occupying it. So, for example, if those parties were to move out, then the certificate of lawfulness wouldn't apply to any successor because it relates to an occupancy condition.
Okay, in that case, members, we have a proposal that we have enough information to determine this case before us. Is that the general consensus of members?
Agreed.
Okay, thank you for that. In that case, shall we deal with the matter section by section as presented within the papers? If there are no dissenting voices, we will go to section 1, notice of review dated 27th of March 2014 and related documents submitted by G.M. Thompson & Co. agents for Mr. and Mrs. Neve, the applicants. So you have the notice of review. Are there any observations on that notice of review? Okay. Section 2, the report on handling determined under delegated powers and related representative comments and correspondence. Have we any comments or questions on that section? No? Okay. Section 3, observation of the appointed officer on the applicant's notice of review. Are there any points members wish to raise on that? No? Okay. Section 4, comments of applicant's agents on observations of the appointed officer. Members interested in that comment? Okay. Section 5, planning application form dated 22nd November 2013 and plans and associated documents. Any questions in relation to that? Councillor Maitland.
Chairman, it's a sort of, I'm kind of slightly thinking on my feet. I'm sorry, we whizzed past it as I was just thinking about it. It was on page 43. Would you mind very much if we went back a section? I'm sorry about this. It's about the applicant's responses to the observations by the appointed officer on that section there. Would you mind if I...
Not at all. Carry on, Councillor Maitland.
Thank you. What it was really is about the points made about 3, because there was reference made to what was local. Do you see where I mean on paragraph 3? Now, unless I've misunderstood, in fact, if it is rather less restrictive, if it's not particular about what is local and what is not local, it would actually make it easier to comply with any conditions. Now, have I misunderstood that?
Robert,
could I have some assistance on that?
I think one of the arguments is that we haven't defined local, and that local has changed over the period of time, and now local in terms of travel to work distance may be greater than was imagined before. But Robert, can you deal with that, please? It's on page 43, a paragraph of section 3, where the definition of locally is under question.
There isn't a definition in the condition, so it's open to interpretation, and that's one of the problems of the condition.
But if I've got that right, if there is no real, if it is not requiring a definition of locally being within, say, 5 miles, it will make it easier to comply with the condition, arguably.
I think the planning officer has sort of admitted that it is up to an individual interpretation. Now, clearly, we all understand in a general manner what local is, but specifically, that hasn't been defined within this paper. Councillor Geddes?
Merely to observe, sir, it's a bit like the word reasonable in these circumstances. It depends upon the particular circumstances of the case. And my own view is that you cannot give a definition as to what constitutes locally. I think you've got to look at it and assess it and judge it against the particular circumstances.
I think
it's called discretion.
I think that's a very useful observation. Thanks for that, Councillor Geddes. Okay, having dealt with that, Councillor Maitland, are you happy with the remainder of that particular section? Okay. Section 5, planning application form dated 22nd of November 2013 and plans and associated documents. Any questions on that? Okay, we'll go to section 6. Section 6, decision letter from Dumfries and Galloway Council dated 11th of February 2014. Any questions on that? Okay. Section 7, relevant extracts from the Dumfries and Galloway structure plan and Nithsdale local plan. Any members have any questions on that? And in that case, the last section, section 8, photos of application site and the locality. And you're on page 73 and only 73. Any questions on that? Councillor McCoftry.
Well, Parsons been up that road. I think, if my memory serves me correct, that sits on the right-hand side as you're heading up towards the village, once you've turned off from the Dumfries to Moffat Road. Where's the farmsteading in relation to that again? Is it behind them trees to the left of the photograph?
Are you able to help with that, Robert?
Yes, if it's helpful, there's a map on page 59 of the papers, and that shows the location of Lakehead. It's on the, as you say, it's on the right-hand side of the road to A, so on the eastern side, and it's just to the north of the farmsteading at Lakehead. So page 59 does give you a map, so that should help, hopefully.
Whilst Councillor McCochtry is looking through his papers, I'll ask Councillor Carruthers. Oh, you want to come back, Councillor McCochtry? Councillor Carruthers?
Thanks, Chairman. Just a general question. Members of the council have recently had information from via the head of Planning and Building Standards in regards to comments back from the Scottish Government on our LDP. Does that have any impact now? Because they're almost, we've not satisfied it, we've not been back to full council. The Scottish Government have laid down what they think about the local development plan. Has that got any implications on what's in front of us today?
Robert, would you like to respond to that?
Thanks, Chair. My understanding is the Scottish Government reporter has come back following the LDP examination and made comments, as you say, on relevant policies. It's my understanding that the Council's development plans team will report to a meeting of the full Council in July and allow the full Council to take a view on how they wish to proceed with the LDP. Essentially, at the moment, there's no substantive change to what the position was, as I understand it, before the LDP was at examination in terms of the weight that you would give to the relevant policies within the LDP. And there is reference, and I notice in the appointed officer's comments, there is reference to, it's the report on handling, there is reference to the emerging policy H3 in the LDP as well, and there's also the supplementary guidance too. So essentially, I don't think there's really any greater weight attached to the LDP now than there was before it was at examination. But obviously, as the LDP progresses and members express a view on that in due course, and eventually it will become adopted at some point, then it will gather weight as the process progresses. But at this point in time, no real change in weight following that, because the Council haven't expressed a formal view on it, as I understand it.
Okay, thanks for that, Councillor Carruthers. Does any other member have any questions at this point in time? In that case, we come to a situation where we have to determine the review, and the options before members are as set out by Claire earlier. We can still at this stage request further information in the form of written representation, resolve to hold a hearing again specifying who will be invited to speak and on what matters, resolve to hold a site visit, and if you have sufficient information you can determine this today. Members? Councillor Carruthers?
I suppose there's still one small query I've got. It's in regards to which hasn't been asked yet, and I'm sorry it just popped back into my mind. Is we're only looking at one condition today, I think, aren't we? One of them was by de facto was because the plan, the outline at the time, permission. it was superseded by through reserve matters, I think it was, or a fuller application. Is that the case?
Robert?
Chair, my understanding is you've got condition 4 of planning permission TP 478, which was the original, what used to be outline planning permission, but which we'll now know as planning permission in principle due to legislation changes. That permission was never implemented, it was never taken further. There was a separate full planning application following that decision, and that's where condition 5 of planning permission TP 596/78 relates. So they got an outline permission, didn't take it further, submitted a full application for all the detail, and that was the one that was implemented. So that, as I understand it, is the condition 5 in question in this application. So it's one condition.
Councillor Carruthers?
Okay, and another quick question, if I can you just come back to the certificate of lawfulness? I know that doesn't apply to this today, we're not looking at that. I'm just thinking, if the case comes, the house was to move on and it was occupied by somebody else, clearly, as it stands at the moment, it would apply that it should be somebody from forestry, agriculture in the locality, whatever the locality is, that would have to be defined, or it's open to interpretation. If somebody was to apply for a certificate of lawfulness at that time, I would imagine that would just be dealt with on its own merits at the time. That's the only piece of information I need satisfied.
I think that's already been clarified, that if this certificate of lawfulness is issued, it will be for the tenants in this particular dwelling at this time, and will not continue on to any further occupiers of these premises. Can you just confirm that, Robert, please?
That's my understanding of it. I mean, there are two separate processes and with two separate outcomes. What the applicant's trying to achieve today is the removal of that occupancy condition from this planning permission. The certificate of lawfulness is to try and demonstrate that they have occupied the dwelling house, not in accordance with that occupancy condition for a period of at least 10 years. And the outcomes are different with the different processes as well. But what they're seeking to do with this review is remove condition 5 of the planning permission TP 596/78.
Councillor Carruthers?
Thanks, Chairman, for allowing me back in. One small other thing, and if a land use has been in use for over 10 years, it's then deemed as having a permission, how does that apply in this case? Clearly, there's been a use for over 10 years, that's been referred to, but obviously there's been a permission granted previously. How does that apply though? I mean, what difference does that make to us in our determination?
Well, I think what they're trying to say is, because the house has been occupied for over 10 years, we will give this current occupier a certificate of lawfulness, but the council have attempted to ensure that that does not, however, become a permission for a dwelling in the countryside per se, and that any future occupancy should revert back to the initial requirement for it to be occupied by a person in either agriculture or forestry. But again, Robert, professional advice please for Councillor Carruthers.
Thank you, Chair. It's just to clarify, the occupation of the house in breach of that condition isn't a use as such. It is being used as a dwelling house all the time, that's accepted. It's the occupation in breach of the condition that the certificate of lawfulness would relate to. And on that basis, you're not talking about a use of land as such, you're talking about occupation by certain parties being in breach of that condition, and that's really the key issue, not the use of the building or premises. So naturally, it would follow that even if a certificate of lawfulness was issued in that respect, it wouldn't change the fact that the occupancy condition would still apply to that property. It would just obviously give the occupants immunity if they could demonstrate that they had lawfully occupied that for more than 10 years. But again, what you've got in focus today is an attempt to remove the occupancy condition of that planning permission.
Councillor Carruthers, okay, satisfied with that, okay. Members, how do you wish to proceed? Councillor Geddes?
Well, I would propose so that we determine it today, because we have sufficient information to allow us to do so. And I would also be of the view that, in fact, on the basis of the papers, on the basis of what we've heard, in fact, that the condition should be required to remain.
Any other member? Councillor Maitland?
I'm in agreement with Councillor Geddes. I don't think there have been any particular changes. I think what we would suggest in terms of upholding that condition, I think conforms with the relevant development plan policies. and I don't think there have been any changes subsequent to that which would indicate that we should change our minds. I do also notice that the applicant's responses in fact suggest that they don't think this review actually was necessary either, given that they have an alternative avenue. That's stated quite clearly by them in page 43. I'm happy to uphold the decision.
Thank you. Councillor Carruthers?
I just feel very much the same as what Councillor Maitland and Geddes is saying, but that last point in particular is where I picked up on, where there's that, so say they wouldn't have went through this process if it had been validated when they first applied for it, so I have no justification why we should make exception to policy in this case.
Thank you very much. In that case, Councillor McCockty, is it a unanimous decision? Thank you. In that case, Claire, can you clarify the review panel's decision, please?
Thank you, Chairman. I can confirm that the local review body have upheld the decision of the appointed officer to refuse refuse planning permission for the application to remove condition 4 of planning permission TP 478 and condition 5 of planning permission TP 59678 restricting occupancy of dwelling house.
Thank you, Claire. On that basis, we will now move on to item 5. Can you just rehearse again the process for item 5, please, Claire?
Okay, thank you, Chairman. Again, I will outline the main points that are in your papers. Item 5 being Glenmaid A. Dumfries' refusal of application for removal of condition 7 of planning permission in principle 10P 30528 condition requiring the completion and registration of a Section 75 agreement to tie the proposed dwelling house and existing dwelling house to the farm holding 13P30574. The grounds of refusal are on page 226. The proposed dwelling house approved under 10P30528 would be contrary to Structure Plan Policy D4 without the requirement for an obligation under Section 75 of the Town and Country Planning Scotland Act being in place to tie the proposed dwelling house and the existing dwelling house to the farm holding. The requested method of determination on page 82, the applicant has requested that the review be dealt with on the basis of an assessment of the review documents only, with no further procedure. The grounds stated in the notice of review are, in summary, that the applicants consider that condition 7 is ultra vires and contrary to national policy contained within Circular 4 1998. The applicants consider that there is no need for a Section 75 agreement. The explanatory text of Structure Plan Policy D4 states that the Council will apply either an occupancy condition or a Section 75 agreement. As Condition 8 restricts the occupancy, there is no need for the proposed house to be also subject to a Section 75 agreement. You have the comments of the interested parties and the relevant development plan policies. The main issues for the local review body to consider are how much weight, if any, does the excuse me. Does the local review body wish to give to the lost my voice. Oh, sorry, voice is gone. No, I'm okay. Got my voice back now. Right. Okay. How much weight, if any, does the local review body wish to give to the agent's statement regarding the legal status of Condition 7 to 10P30528, noting that it was the practice of the Council at the time to use suspensive conditions requiring the completion of the Section 75 work before work took place, but only with the prior agreement of the applicant. Does the proposal conform with the relevant development plan policies, and in particular Structure Plan Policy D4? Is there still a need to tie the proposed house to the farm unit by way of a Section 75 planning obligation? and noting that the agent explicitly states on page 150 that I confirm that my clients are not willing to enter into a Section 75 agreement, that would be the effect. What would be the effect of upholding this Section 42 application, which would effectively grant a new planning permission for the house without a Section 75 planning obligation? How much weight, if any, does the LRB wish to give to the letter from the former Chief Planner dated 4th of November 2011 and the applicant's particular interpretation of it? And as before, the local review body has the same options as previously outlined.
Thank you, Claire. Any questions for Claire at this point? In that case, are members happy to adopt the same approach whereby we deal with this item 5 section by section? Okay. Section 5, the refusal application for removal of conditions 7 planning permission. Any questions on that particular notice? Section 1, notice of review dated 14th of April 2014 and related documents submitted by Anderson Strathern LLP, agents for Mr and Mrs Booton, the applicants. Any questions on that? Okay. Section 2, report on handling determined under delegated powers. Oh, sorry, Councillor Maitland, my apologies.
So I just want to it's on page 93, it's the issue about national planning policy. It's a paragraph in italic, second one down. National planning policy indicates it's unlawful to require parties to enter into a planning agreement by way of a planning condition. I don't know when you want to deal with this, but I do think we need to pick through the business of when there was a change made in the council's procedures, or if indeed there actually were. I think it would be helpful to tease that out, Chairman. I'm not sure where you want to do that, but...
Happy to do it now, Councillor Maitland. I think that the point being made is it's unlawful to require parties, but we seek to engage with them to get agreement. But Robert, can you deal with that now? Is that appropriate?
Quite happy to advise, Chair. I mean, my view looking at this obviously is it's quoting Planning Circular 4 of 1998, which gives guidance to planning authorities across Scotland on the use of planning conditions. There is guidance within that document that says you should not, or well, rather it says it's ultra vires to use a planning condition to require a legal agreement, which is now known as a legal obligation. Now the guidance in that circular is still extant, so it's available for planning authorities to follow. Ultimately, in terms of it being ultra vires, it's a matter for the courts to decide whether or not it is or not, but certainly that guidance does exist in Planning Circular 4 1998, quoted in bottom of page 92.
Councillor Crothers and Councillor Geddes.
Just a small comment. I think we come up against this all the time, same circumstance with wind farms. We've seen it again and again and again as applications come in. It's something I would like to get into debate as we go further into this report, so I think it's one of the critical points.
Thank you, Councillor Geddes.
Well, guidance is the key word that Robert has used, Chair. You know, and it's the question of what weight, you know, not only this local review body today, but, you know, the wider Planning Applications Committee, etc., is prepared to afford to such guidance in the particular circumstances of the case. And I think Robert is quite correct. Ultimately, you know, unless matters are judicially determined, there is always the inference that, well, okay, you can take the guidance. It was once famously said, without being disrespectful to anyone, and it was a circular that was produced in a civil case by the then Sheriff Principal of South Strathclyde, Dumfries and Galloway, that his assessment was that these were the views of mere civil servants. Now, I'm not suggesting for one moment that, you know, we go to that length, but, you know, it's interesting to know that on occasions that perhaps is the attitude that certain members of the judiciary you know, afford to such guidance. I would never be as foolish or as disrespectful myself, but I think it's important, you know, to appreciate it is guidance. It's nothing more than guidance until such time, Chair, as it's judicially determined.
Grateful for that, Councillor Geddes. Councillor Maitland? Okay. In that case, we'll move on to section 2. Report on handling determined under delegated powers. Any member, any question on that? Okay. Section 3, observations of the appointed officer on the applicant's notice of review. No. Section 4, comments of applicant's agents on observations of the appointed officer. Any questions on that? No? Okay. Section 5, planning application form dated 16th of December 2013 and plans and associated documents. Any questions on that? Okay. Section 6, decision letter from Dumfries and Galloway Council dated 5th of March 2014. Any questions on that? No? Okay. Section 7, relevant extracts from the Dumfries and Galloway structured plan and Nithsdale local plan. Any observations on that? No. And the last is item 8, photos of the application site and the locality. And you have the photographs on page 235 and 236, the last 2 pages in the papers. Okay. Right then, members, we are in the same position again. The options available to us are, we can decide with sufficient information before us today to determine the review. We can request further information in the form of written representations. We can resolve to hold a hearing again, specifying who may be invited to speak in what matters. Resolve to hold a site visit. And if the local review body resolves that sufficient information and no further procedure required, then with the full powers to uphold, reverse or vary a determination. How do you plan to proceed, members? Councillor Carruthers.
I'm happy to proceed today, Chairman. I've got enough information.
Councillor Geddes.
I would certainly support that, sir.
Okay, thanks. Is there any alternative view? In that case, we'll determine it today. I'm open to you, members. Councillor Carruthers and Councillor Geddes.
And I suppose my question is in regards to probably some advice from our appointed officer in regards to the condition. It's accepted within the report that it is antivirus. He's already said that. But Section 75, could you give us some clear outlines how Section 75 obligations or legal agreements should be applied, and how would the council would normally apply these, just so we've got a full background. And what's being asked for here is I think, from my understanding, is that the conditions should be removed from the applicant, that is, of the review, and there's no need for a Section 75, and we've had advice for the chief planner in other circumstance. Just get an understanding for the appointed officer what his thoughts are on that, please.
Robert, do you want to? I think the issue is, and Robert will speak to it, but I think the issue is agricultural justification is required to justify a house in the countryside, and to remove Section 75 would be tantamount to granting a house in the countryside which is contrary to current council policy in relation to development in the countryside. But Robert, do you want to address that question, please?
Thank you, Chair. I haven't considered the content of the papers, and particularly the appointed officer's comments on page 143, paragraph 3. The Section 75 obligation would tie the dwelling house to the farm or the rural business to which it relates and upon which the justification is based. Understand that it would tie it as a legal and a planning entity so that no part of it could be alienated or let from each other. So it basically keeps the whole parcel intact, if you like, post-decision. Looking at the practice of the Council's Planning Authority, again, I think the appointed officers covered this in page 143, so my understanding is at one point in time there was a practice of using a suspensive condition to require someone to enter into a Section 75 legal agreement before development commenced in site, and that allowed early release of the decision notice, so it was considered to be beneficial to both parties. However, that practice has now changed, and you'll get situations whereby the decision is not issued until such time as the Section 75 legal obligation has been completed and registered as well, and confirmation's been received from Registrars Scotland to that effect. So, as I understand it, the practice of the Council has now changed with these matters.
Councillor Carruthers, then Councillor Geddes, then Councillor McCauley.
Thanks, Chairman. Because when I was reading this, my whole thoughts were the Section 75, without predetermining it, should apply, but it's how do we actually make that apply in this case? But I think you've enlightened me to a point where the permission or the decision notice wouldn't actually be served until such time as that agreement was in place. Previously, this was a detriment to the performance of the council, certainly on paper. It looked as if, and that's why it was conditioned. So what I'm looking reassurance is that this can be applied for if the review body, because in my mind at the moment, certainly, after you hear all the different arguments that we put today, is that Section 75 should apply. The condition must be removed. I think that's absolutely sure. But how will that apply to the decision notice? If the Section 75 was to be applied today, the decision notice being then given out, how does that apply time-wise? That's the only wee bit of confusion I've got, or the wee bit I've still got lost. I take it because it's timelines involved in it. That's what I'm thinking of more than anything, just to be absolutely clear. Could that mean it hold it up for a month, a week, a year? What does that mean?
Okay, we'll have the other members and then we'll get back to you again at the end, Councillor Phillips. Councillor Geddes?
Well, I think the first point, as far as I'm concerned, sir, is do we concede or do we accept the applicant's agent's submissions that are well founded in relation to condition 7 being ultra vires? I think I personally would find that helpful to get that out of the way in the first instance. And I would have to say that from the perusal of the papers and reading the arguments, I would be inclined to support that view that the purported condition 7 is in fact ultra vires. And therefore, if the finding of if the local review body today support that, I think the next step in the process is to move on to whether or not there is a need for a Section 75 agreement, standing in particular, Chair, that we have an occupancy condition there, condition number 8, which I think it could be argued provides exactly the same what's the word I'm looking for? Reassurance, for want of a better term. And would have the same effect. So, in other words, to use a colloquialism, as a Section 75 agreement, on the top of condition 8, is that maybe perhaps a wee bit too much of a belt and braces. But again, as I say, I'd be interested to hear our advisors' comments and fellow councillors' views on that as well.
Thanks, Councillor Geddes. Do you want to respond to Councillor Geddes at the moment, Robert, in relation to that question?
Yes, I'm quite comfortable in doing so. As I understand it, you may or may not be minded to remove the condition in question. However, you may or may not seek a Section 75 agreement, and if you are seeking to have a Section 75 agreement, you're just wondering if that's possible or not to do that as a review body. Is that a correct summation?
Councillor Geddes, does that sum up your question?
Yes, as I say, I'll accept the response, but I would reserve the right to come back, when we're into the proper debate stage, sir. Thank you.
Robert?
Thanks. It was just that when I considered this, having looked at all the review papers before today, I had looked at this issue and thought about this. In effect, what you would then do would be...
I feel a wee bit embarrassed about asking this, but can Robert, sort of pull his microphone closer and speak, it's not meant to be disrespectful, it's just that some of us have more acute hearing than others.
Good, Robert, you speak up.
Apologies if I haven't been clear enough. Okay. Looking at that scenario, you could obviously, as a local review body, remove that condition. The difficulty arising, having looked at the papers in the last couple of days, is that on page 150 of the review body's papers, so these are the agent's response, the applicant's agent's response on the observations of the appointed officer. They've said at the second last paragraph on page 150, I confirm that my clients are not willing to enter into a Section 75 agreement. And they've expressed the view that it remains the case that the Council's planning policy does not require this. If, as a local review body, you are minded to strike the condition but say suspend issue of a formal decision until such time as a Section 75 agreement had been entered into, you would essentially be forcing the applicant to enter into a planning obligation against their will or a planning agreement against their will, when clearly that's not what they want to do, and in essence similar to the difficulty with the condition, in the sense that you're forcing someone to do something, enter into a planning agreement when it's got to be of their own volition.
That's helpful, Robert. Do you want to come back before I bring Councillor McCaughey and Councillor Geddes?
Well, very, very briefly, sir, but of course the applicant's position and the penultimate paragraph of page 150 is predicated on their belief or their assertion, in fact, that Section 75 agreement, is really superfluous anyway. I'll leave it at that.
Thank you for that. Councillor McCaughey.
Yep. I mean, I think when you go back to 2006, one of the worries those of us who were in this Dale Planning Committee had was the number of applications that was coming in. The belt and braces approach was to have a Section 75 or some condition on it. And let's be frank about it, if there wasn't any conditions put on that particular development, we wouldn't have got planning permission. It fell out with policy, etc., etc. So it's either there for agricultural use or some other predetermined use. But if it's just a house standing on its own, would we have granted planning permission? I don't think so.
Thanks for that. And I take it that policy is still in existence now. Councillor Carruthers.
Thanks, Chair. I think Councillor Geddes is absolutely right in this. I think it's understanding the difference between condition 8, I think it was, but the condition that the occupancy condition and the Section 75. What's the difference between them? Should we apply one or the other? I think if we get an understanding of that.
It may be challenging, but I'll ask Robert to do that in layman's terms so that everyone understands exactly the difference between Section 75 and an occupancy condition. Robert, please, in layman terms.
The occupancy condition is attached to the planning permission, and therefore the land. It's attached to the planning permission, and therefore the land, by virtue of being attached to the planning permission, and it basically, during such time as it exists, it restricts occupation of that dwelling house. The legal agreement, and if you're looking at Section 75, legal obligation as it's known now, is entered into. It's a contract between the council and the same applicant. What it does is it ties the house to a particular land holding or parcel of land or buildings or business as a single planning and legal entity. And the clauses within that are normally such that you cannot alienate the house thereafter from the business without obviously seeking to change that legal obligation with the council. So it gives the council an element of control over, the future disposal, if you like, of the house relative to the business upon which the justification rests.
Is that near enough? Because I presume what you're saying is that we could go back to the locality issue and an occupancy condition could be working in a farming or forestry within the locality, whereas the Section 75 ties the property to a specific piece of land and therefore a specific restricted activity within that piece of land. Is that right, Robert?
It's more the land unit in itself rather than a range of activities. So, for example, if you had a house which was tied by Section 75 legal obligation to a business, the business wouldn't necessarily need to stay the same in terms of its range of activities, but normally a farm would maybe diversify over time, but it's still going to be tied to that farm unit.
That's helpful, Robert. Okay, Councillor Maitland.
It's a stupid question. If we're looking at this de novo, could we simply refuse the whole thing?
Robert?
It's entirely at the discretion of the local review body. Yes, that is an option for you.
Thank you, Robert. Okay. Any other questions? No? In that case, we come to a determination then. Does anyone have a proposal? Councillor Carruthers?
Thanks, Chairman. I mean, after hearing the explanation of the condition, I'm satisfied that the condition's appropriate in this case. I'm happy with it, and I think with the information or the advice that we've been given, that the previous condition 7 should be removed.
Councillor McCaughey.
I mean, I don't think that we should lift the condition. I think if people have houses without conditions, make a fresh application, quite frankly. I know why conditions were put on. I was a member of that committee. hundreds of these coming to the area committees in them days, and that's why conditions were put there. If people want to build houses in the countryside, be open about it, put an application for a house in the countryside. If they say it's part of their business, then there should be conditions attached and it remains part of their business. So I see no reason to change the decision that was made.
Councillor Carruthers.
Can I just come back and clarify your condition? I mean, I thought condition 7 was a must. Maybe I picked that up wrong. I thought it is antivirus, that's the advice that's been given, and that should be removed. It's condition 8, it was the occupancy condition I was talking about. I didn't think there was really much option in that. I felt lawfully.
Well, I'll ask Robert, because Councillor McCaughey has proposed that we adopt the officer's recommendation in its entirety. Robert, do you want to respond to Councillor Carruthers' question, please?
Okay, thank you, Chair. I'm struggling with this microphone. Looking at condition itself, condition 7 itself, rather, I'm just trying to find the exact wording of that. Yeah, it's on page 135 of your papers, within the delegated report. Condition 7, which is the one in question, says that no development in respect of this planning permission shall take place unless an agreement under section 75 of the Town and Country Planning Scotland Act 1997 tying the proposed dwelling house and the existing dwelling house to the farm holding has been completed and registered. So in essence, the condition is being used as a catalyst for section 75 agreement in this case, so the condition requires that to be a prerequisite of development.
But it does use the word agreement, so if the applicant doesn't agree, then they just choose not to progress with their application. That's how it reads to me, but I'm open to other members' interpretation of that particular condition. Councillor Carruthers.
Actually, I'm sorry for labouring this. It's the observations of the appointed officer and the advice we've been given since. And under that first section, it says condition 7 is ultra-virus. And contrary to national planning policy contained within the circular 4/1998.
Would you be kind enough to tell us what page you're referring to?
Page
please?
143, sorry, Chairman.
143.
Page 143, it's the advice or the observations of the appointed officer, which I think is referring to David City from memory, which it is, yep. And he's saying quite clearly, and it's paragraph 1 of section 1, you could say, condition 7 is ultra-virus and contrary to national planning policy within circular 4/1998. And that's advice that we were given earlier. That's why I asked that specific question.
That's the reason for the review. That's not the officer's opinion. The observation of the appointed officer, the two main grounds for review of the refusal with non-compliance are condition 7 is ultra-virus. That's the observation. That's the observation by the applicant.
I thought I asked that. I thought that's
not an acknowledgement by Janice Kay that was correct.
No, but I know. Right, apologies if I've got that wrong, but I thought that's advice that Robert had given us earlier as well, that it was antivirus when asked the question. But maybe it's not.
But even so, that then goes to a court of law to determine, I think, as far as Robert said. But Robert, will you just address that, please?
What I was doing was just clarifying the guidance in Scottish Government Circular 4 of 1998. Just to answer that earlier question more correctly as well, on page 176, if you look at paragraph 11, at the second last sentence, you've got the exact wording in the annex to Circular 4 1998 in respect of that. I was trying to remember it from the top of my head and tends not to work sometimes. So if you want the exact wording, it's on page 176, paragraph 11, and it's the second last sentence. So that's really what I was clarifying, with regard to the condition being ultra vires, if you like. It was just merely quoting the guidance within that document.
So to save absolute confusion, if we accept the planning officer's decision in its entirety as had been proposed by Councillor McCaughey, is that a legitimate approach to make?
There's nothing I can see that prevents the local review body from taking such a decision, no.
Thank you, Robert. In that case, we have a proposal from Councillor McCaughey. Councillor Maitland?
I'll second that.
Councillor Geddes?
Well, as I've already indicated, sir, I mean, I am by no means convinced. I personally think that, the applicant's agent's submission that condition 7 is ultra vires is in fact well founded.
Okay. Do you have an alternative proposal? Councillor Carruthers?
I mean, I did put a proposal in first, but
I apologise then. Would you like to repeat what your proposal was?
just that we should grant it subject to the conditions that are already applied, not ask for. We should remove condition 7, and it should be granted subject without a Section 75 legal obligation.
Okay, so you have that proposal. Is there anyone in support of that proposal?
Well, yes, as I say, I am minded to support that, but let's be, let's have it made abundantly clear to us yet again, as it were, to do that, to regard condition 7 as ultra vires, and also in the circumstances to take the view that Section 75 agreement is basically superfluous, standing in terms of condition 8. What does that leave us with then?
Robert, given that question, remove condition 7 and leave condition 8 as is, what does that do?
Sorry? Yeah, yeah, exactly so, sir. You're removing your section. We're of the view that, or some of us are, that condition 7 should be struck down because it is indeed ultra vires. And therefore you move on, if that is well founded, you move on to the issue of the Section 75 agreement and the existence of condition 8. Now, are both of these necessary, or can you turn around and say, for instance, the Section 75 agreement, and I'm not being influenced in any way, shape or form by the applicant's agent's comment that his clients wouldn't be prepared to enter into such an agreement, but would it in fact, would that be superfluous, standing the terms of condition 8? The thrust of my question really is, does the terms of condition 8 give the council as planning authority sufficient surety to ensure in fact that we're not allowing the proverbial coach and horses to be driven through the policy?
Okay, so you remove condition 7, you retain a Section 75 in condition 8, and you want Robert to advise you what the implications of that are.
I would be grateful for that advice if Robert feels in fact that it's appropriate for him to give it, sir.
Robert, can you do that? Remove condition 7 and tell us if we can then apply a Section 75 agreement and retain condition 8 and what, in effect, that will do.
Thank you, Chair. I'll try and cover this as best I can. If members of the LRB find that they wish to remove condition 7, then logically the requirement for the Section 75 agreement by means of that condition falls as well, so that element of it disappears. Yeah. If members are minded to retain condition 7, then it would obviously be open to legal challenge. That's not part of your question, I accept that, but the corollary of that is that would be the situation. Looking at condition 8, that's the occupancy condition which is unaffected by this proposal. That's going to exist anyway. The difference between the condition and the Section 75 agreement has been summarised reasonably well by the appointed officer in Section 6. Sorry, page 144, paragraph 6 rather. So the section, just picking up on this, the Section 75 obligation ensures that the dwelling house is available for the agricultural business in the long term because it's tied to that land. The ability to sell or lease the dwelling house separately with no restriction may generate the need for an additional dwelling house given the asserted essential needs in this case. This would result in unnecessary sporadic development in the countryside. The occupancy condition serves a separate purpose of ensuring that the occupants are employed in agriculture. So really those are the key differences. As I alluded to earlier, if you're minded to remove the condition and still wish to see a Section 75 agreement entered into, again, the applicant's agents made it clear that they're not willing to do so, but again, I suppose there's nothing to prevent members of the local review body to ask the question in the circumstances that condition 7 was removed, would they be, minded to enter into a Section 75 agreement or not, just for the purposes of clarification, recognising that circumstances have changed since they maybe made that statement. But that's obviously a matter for members of the review body to decide.
Thank you for that, Robert. Councillor Geddes.
Thanks, Chair. And the question on the back of that, of course, would be that can the council as planning authority competently ask, in fact, or stipulate that such a Section 75 agreement will indeed be entered into, notwithstanding the striking down of or the decision to accept that Condition 7 is ultra vires?
I think Robert has said he would engage into or engage with them to find an agreement, because we can't require, as far as I understand it, we can seek an agreement. Can you just clarify that, Robert, please?
I'm aware that the present practice of the council is to, in situations like this now where something is reported to committee, is to recommend approval subject to conditions, but with the prerequisite that a Section 75 agreement is agreed and concluded beforehand. So certainly I think it's legitimate for the LRB, if you're minded to go down that route, to then approach the applicant and say, notwithstanding the comments you've already made, would you be willing to enter into a Section 75 agreement, in which case they could say yes or no. And then you would obviously be informed, if that would then inform your decision after that as to how you would wish to proceed. It might be a helpful way to operate, but that's obviously up to your discretion.
Councillor Geddes.
Thanks very much indeed, Chair. And if the applicant's agent, as presumably would be the case, adheres to the position as per his, presumably his client's instructions, and says no, where does that leave us?
Robert.
If you were minded to agree to remove Condition 7 and they were not minded to enter into a Section 75 agreement, I mean, essentially once you remove Condition 7, then there's no requirement for the Section 75. Once that decision's been taken, you know, that requirement would fall, but Condition 8, the occupancy condition, would still prevail, because that is not under, you know, they're not seeking to change that as part of this review.
Thanks, Robert. Okay, we seem to have exhausted that area of inquiry. So we have, unless you wish to amend it in any way, you have a proposal from Councillor McCaughey, seconded by Councillor Maitland. You have an amendment that's approaching some joint agreement between Councillor Crothers and Councillor Geddes. If you still wish to place an amendment, can you maybe establish what exactly that is?
I mean, I still feel that after the advice given, at the end of the day, what I propose will come to the same conclusion. Ken, we may ask for a willingness towards having a Section 75 legal agreement. The way it's been worded, if we ask for that, it's up to the actual applicant at that time. They will have the permission no matter what. So if that willingness is there, it will happen. So I mean, I'd be happy enough to leave it as it is. I think a fully suspensive condition is strong enough in the circumstance. That's my feeling on it. But so, and I think it's appropriate that condition is strong enough, and the Section 75 legal agreement is not required.
So be very specific, please, on what it is you propose with Councillor Geddes. It seems a bit vague. Well, can you just exactly determine what it is you wish to agree or have, hopefully, the board agree?
I could say,
Councillor McCaughey, I'll come to you.
I mean, I could say in simple terms to uphold the review in regards to removal of Condition 7, and that would be it, I think, in really simple terms, and the rest would conclude from that. And that's what I'm saying in real terms, is that the condition should be removed. That's it. Everything else would just fall automatically, and it to be approved. They're asking for the condition to be approved. There's questions asked earlier, what can we do with this? Do whatever we want, because it's de novo, we're starting from scratch, but I think we should just remove the condition, and it be approved.
Councillor Geddes.
Well, I've no problem, sir, supporting that, provided that we're fully aware just exactly what the implications are. And if in fact, we take that decision and, automatically what flows from that decision, in fact, is the striking down of the Section 75 agreement, or the necessity for it. So therefore you're left at the end of the day with the Condition 8 and the planning consent, which I would be inclined to agree with Councillor Crothers on, provides sufficient assurance, as it were, for the council as planning authority. So on that basis, I will second his amendment.
Okay, now I'll ask, before we absolutely finish, I will ask Robert just to clarify exactly what the implications are, but Councillor McCaughey wants to speak.
Yeah, see, one of the problems I've got is if you remove Section 7, right, what that de facto means is that you have the new house there, which is covered by Section 8 of occupancy, but it then means any other houses in that farm can then be disposed of with no occupancy or whatever else. It was with the, when you've got Section 7 in there with the Section 75, it does refer to the other dwelling house. So, you know, they might as well have asked to build a house in the countryside that they could sell, and that's effectively what it means. Now, if you allow this in this one, you're making a mockery of the whole factor of Section 75. We get these people coming in all the time trying to waive the Section 75s that have been granted. We usually refuse them, and I think we should stick to that, because all we're doing is allowing for other properties to be disposed of if we take that Condition 7 out.
Robert has already advised us that the appointed officer's response in page 144, section 6, deals very succinctly with exactly what you're saying, Councillor McCaughtrey. That the ability to sell a lease may separately, no restrictions, may generate the need for an additional dwelling house for the business, given the asserted essential need. This results in unnecessary sporadic development in the countryside. That's what the officer is saying. That's section 6 on page 144, the appointed officer's response to ground 2 lays out their view in relation to this particular application. However, notwithstanding that, we now have a motion and an amendment. Claire, will you just determine, or I did say I would ask Robert to clarify exactly where we are with the amendment, and I'll ask Claire if it's appropriate, and then we'll go to the vote.
Thanks. As I understand it, the amendment is to simply approve the application. So take an alternative decision to the one that the officer did and delete Condition 7, which then deletes the need for a Section 75 agreement, in full recognition of the fact that Condition 8 still remains attached to that permission and limits occupancy of the dwelling house.
Thank you, Robert. Members satisfied they understand what's happening, okay? Claire, can you just tell us that that's an appropriate amendment, and then go to the vote, please?
Thank you, Chairman. Right, just to summarise here, I've got a motion proposed by Councillor McCaughtrey, seconded by Councillor Maitland. It's basically to uphold the decision of the appointed officer that the planning and permission in principle be refused, and an amendment proposed by Councillor Carruthers, seconded by Councillor Geddes, that the decision of the appointed officer be reversed and that planning permission in principle is granted, deleting Condition 7 whilst recognising that Condition 8 is still intact. Is that correct?
Certainly from my point of view, yep, Condition 8 certainly satisfies me that's satisfactory for me.
Okay, Claire, in that case, proceed to the vote, please.
Okay. Chairman, motion or amendment?
Motion.
Councillor Carruthers.
Amendment.
Councillor Geddes. Councillor Maitland.
Motion.
Councillor McCaughtrey. Okay, in that case, the motion is carried 3 votes to 2. The decision of the appointed officer is upheld to refuse the planning permission in principle.
Thank you for that, Claire. I have no other business today. Thank you, members and officers, for your attendance. Thank you very much.